Yes, Mr. Glover.
My Lords, my Lady. The next topic I'd like to touch upon is the rating hypothesis. I admit to being somewhat in two minds about how to deal with this. I've given you some edited highlights before the adjournment. We are quite full on the subject in our case from paragraphs 20 to 44, which are to be found for your notes. I'm not going to ask you to turn it up. On MS page 99 to 106. What in the event I decided to do was to ask your Lordship's attention to the judgment of the Court of Appeal, which turns to the relevant principles of the rating hypothesis at MS page 150 and takes them in paragraphs 31 to 40 through to page 153. And what I propose to do, if it's acceptable to the court, is not to read all of this out, but to identify, by turning the pages and pausing at individual elements, points on which I wish to draw particular attention. And so I start with Lord Justice Scott in Robinson, quoted in paragraph 32 of Lord Justice Henderson's judgment. The rent to be ascertained is the figure at which the hypothetical landlord would, in the opinion of the valuer or the tribunal, come to terms as a result of bargaining for that hereditament in the light of competition or its absence in both demand and supply as a result of the higgling of the market. I call this the true rent because it corresponds to real value. Actually, in the judgment itself, Lord Justice Scott goes on to explain why he balks at using the word market, the phrase market value. And that is because in the particular case, which was to do with whether in valuing a public house, you should take account of the potential bids of breweries, who in those days were very keen to occupy public houses as tied houses. And the court below had drawn a distinction between market value as a figure, which was the rent before you started looking at what the brewers might say, and then some higher value if you took into account what the brewers would bid. And Lord Justice Scott says, well, that's a bit of a bastardization of the concept market value. What I'm looking at is the highest rent that would be paid in the market, and is market valued to that extent. And he went on over the page, and this is, I mentioned this before the break, the objective being the real value of the actual hereditament, and I emphasize those words, real value, actual hereditament. The inquiry is primarily economic and not legal. It's only legal insofar as logical relevance is the measure of legal admissibility. Although Lord Justice Henderson goes on, the yearly letting is hypothetical, the open market in which it's assumed to take place is real. He then refers to IRC and Gray. By virtue of Section 38 of the Inheritance Act, the value to be identified was defined to be what it would fetch on the open market at the time, and Lord Justice Henderson recorded the agreement between ourselves that the open market, which has to be assumed under Section 38, is materially identical to the open market posited by the rating hypothesis. In other words, the point that Lord Justice Scott was on in that strange distinction in the court below him. At paragraph 34, the court below, Lord Justice Henderson, quotes Lord Justice Hoffman in IRC Gray some moments further. In all other respects, the theme which runs through the authorities is that one assumes that the hypothetical vendor and purchaser did whatever reasonable people buying and selling such property would be likely to have done. 3 or 4 lines down, the hypothetical buyer, slightly less anonymous, ... reflects reality in that he embodies whatever was actually the demand for that property at the relevant time. It cannot be too strongly emphasized that although the sale is hypothetical, there is nothing hypothetical about the open market in which it's supposed to have taken place. And Lord Justice Henderson, in paragraph 35, takes this lesson, which I commend to this court. It can be seen, therefore, that the hypothetical purchaser, or in the present context, the hypothetical lessee, embodies whatever was actually the demand for that property at the relevant time. We then have the National Trust case.
In that, when he says the hypothetical buyer is slightly less anonymous, it is in that respect that he has to be identified in the actual demand at the relevant time. Is that the point?
That he represents that demand.
Is that, I mean, that's put quite strongly and clearly. Is that supported by any other authority, that proposition?
Well, it is endorsed by the Court of Appeal in the rating context in National Trust, which is what's dealt with in just the next paragraph. And I would say to you that it is endorsed. We will take a little bit more time to look at Erith and Robinson in a moment to deal with a point that is in my learned friend's case. But I will, after taking you to those authorities, ask you to accept that they are a very good source for this proposition in the rating context. But the two that are particularly before us at the moment are Court of Appeal authorities. And we then have Hoare and the National Trust, which is well known in rating for 2 things. One, it is one of the cases in which, although you have a hereditament that is clearly occupied and ex hypothesi occupiable, it nonetheless has a nominal rateable value. These are Petworth House and Castle Drogo. Another example is BTC and Hingley, which concerned Hull Docks in the 1960s, which was making a loss year upon year, and nonetheless was occupied. And the conclusion that the tribunal came to, endorsed by the Court of Appeal, was that, although clearly occupied, should be valued at £1, or at least at a nominal number. So that's the first reason why National Trust is of interest in rating. The other is because it is the case in which it's made very clear in the modern forum that the reality principle applies, and that one should depart from the real world only to the extent to which the hypothesis requires you to do so. And I say that's not only a point of high authority, it also makes sense. If you're running a tax system that's based on the occupational value, the rental value of a property as at the valuation date, then the exercise should be, as much as possible, untrammeled by artificiality and hypothesis. Because if you don't do that, you're going to magnify in my submission and multiply the number of anomalies and unfairnesses that result. Over the page, compendiously treated in a quotation from Plymouth Argyle, is the point that I took the court to before the break. The court must not assume hypothetical tenants for the hereditament if there is, in respect of that particular hereditament, no reasonable possibility of such tenants existing. In Great Western and Metropolitan Railways, Lord Buckmaster had said, the phrase hypothetical tenant, which has for a long time described the character of the tenancy, must not be allowed to introduce the idea of creating hypothetical competitors or hypothetical circumstances by which to fix the rent. And in that particular case about Plymouth Argyle football ground, the final sentence, there was no evidence that some tenant might be found for some alternative use, and without such evidence, it's wrong to assume it. And finally, we have ladies' hosiery. The assessing authority should not sacrifice correctness to uniformity.
Can I just pick out that point and what you think about the hypothetical competition? I mean, if you go back to page 8, MS page 82, where Miss McCarthy cites the Lord Gill, in the hypothetical world, one assumes that the demand is available to meet the supply.
Yes.
Now, that seems to me rather contrary to what is being said by Lord Justice Pearce in the passage you just read.
My Lord, I have quite a lot to say about Barrett International. Let me give you...
No, if you want to come to it later,
please let me at least give you an indication of how I will seek to settle that in your mind. The first point is that if one looks at the words purely on their face, then it may be that there is a contest between them. And if that is the case, then I say that Plymouth Argyle and Lord Buckmaster in the House of Lords in Great Western Metropolitan Railway, not only is the higher authority, it's also the better authority.
Well, it's not a higher authority except insofar as we're sitting in an English appeal. It's the same level of court.
Well, my Lord, the point I was making, and I take the point about different jurisdictions, mean that what I was saying was slim in any event. But Great Western is in the House of Lords, none of the others is.
Yeah, well, I understand. I'm trying to get at the principle. I'm less interested in the hierarchy.
And then when one gets to the detail, and I will take you through this later on. Why don't I do it now, actually, my Lord, since you ask? May I just put a sticker where I was so that I come back? Actually, thinking better of it, I'd like to build up. The point is
I shall wait with eager anticipation.
The point is going to be this: that what Lord Gill's comment is in the context of an argument by the ratepayer which sought to use the rating hypothesis to distort the balance between supply and demand, and to do so in the context of a case where there was no question of demand being exhausted, being extinct, but where what was being argued was if you are going to assume that these houses, these timeshare units that are suddenly going to be coming onto the market in the rating world, that will reduce the supply, and therefore the general level of rent will be reduced. To which there are several responses, and the one Lord Guild chose, and only in that context, was to say, well, if you increase the supply by putting on the market the timeshare units that are actually that are owned by the neighbours, you also increase the demand because they show a demand for those, and therefore the general level of value will float with it. That's not talking about a case where it's certainly, in my submission, Lord Gill would be very surprised if anybody said to him that what he was saying was that you should distort the rating hypothesis so as to alter the real-world balance of supply and demand.
There isn't really any inconsistency with Tomlinson, is there? In there, or what's being said is that there has to be a hypothetical tenant. The statute requires that, and the hypothetical tenant would have to be somebody with the same characteristics as Plymouth Argyle Football Club, because nobody else would take the property in the absence of any evidence of an alternative use.
I would agree with your lordship that there's no necessary difference between Barrett and Plymouth Argyle, so long as Barrett is not read as saying you create, by this assumption of the other neighbours being part of the market, some sort of demand for this hereditament which doesn't exist in reality. As soon as you take that step, and I say that's not the step that Lord Gill was taking, then there is, in terms of practical effect, there's no difference. There may well be a difference in the way in which the two courts get to the same result, but in practical effect, there is no difference. The problem for my learned friends is if they are going to get anything out of Barrett, it's the proposition that they can generate a demand for this hereditament out of the assumptions made about the tenure of other hereditaments. That's the leap they have to make, and I say that's illegitimate. And up to that point, I'm indifferent.
Well, you're only saying it's illegitimate as a sort of rigid proposition of law. I mean, in practice, that's what valuers probably do all the time.
Forgive me, my lord, I'm not sure that I follow that.
I think you're saying that they can't use it to show that, regardless of the opinions and evidence about actual demand for this hereditament, you can't use what's going on, trumping it.
That's right. Yes. But if you're in a state, which most valuers are most of the time, where there isn't an argument of the sort that we have in this case, that this particular unit, for all the factual reasons that I will elaborate on in a moment, is not going to find itself another tenant. If you're not in those circumstances, then habitually valuers say, well, because property X is going at Y pounds a unit, this one is a bit better, a bit worse. Absent evidence to show that the demand levels are different, I read across in some way, making adjustments as I go, as I might. That is the usual world, and it's the world that was being talked about in Barrett. It's not the unusual position of this case, where the evidence has a priori shown the absence of demand in the real world for the appeal hereditament. do need to turn to the context. I've already looked at the content of the joint position paper, but I do need to turn, in the light of the length of time my learned friend took on it, to its context. Though I do say this in opening on this aspect, in my submission, it matters little in the end how and why one got to the JPP. The fact is that we got there, and that's the starting off point for the courts. My learned friend took you to the tribunal's pleading, which is at page 343. I'm going to dance through this a little more quickly, I hope.
Can I just ask you, before you start dancing through it, do you accept that the subjects are appropriately valued on the comparative principle?
My Lord, I accept that if the levels of demand are the same, or are required to be taken as the same, then they fall to be valued on the comparative principle.
Then the subjects have to be valued in some method or other, and apart from the comparative principle, the contractors and the revenue principle, and anything else that's been invented since I stopped doing this type of work, I'm not aware of any others. But the comparative principle is premised on the comparability in the market of the properties.
It is. It is. And that is why it only is applicable where the comparability of the market is shown. And that is a less extreme submission than it might sound, because in 99 cases out of 100, the comparability is shown. Or to put it more accurately, the ratepayer fails to show a lack of comparability. And the tribunal's default position is to assume comparability.
But where it's not shown, if you're dealing with a football stadium, for example, you would use the contractor's principle, I think.
I believe, actually, that valuation
or the revenue
was a rather odd one. There was a rent on part of it,
right.
And the VO constructed the valuation by taking that rent, adding a bit of, which was a
well, the details don't really matter, but you get my point, that if a hereditament is one which doesn't have comparable properties in the market, then you adopt a different method of valuation.
Well, with respect, the detail is perhaps informative to this case, because the alternative position of the ratepayer was there's only one tenant, so the landlord gets what that tenant offers, and that tenant can hit a one-off figure and then say, take it or leave it. And he said that was £500. And what the Court of Appeal said, essentially, was tribunal went wrong because they thought of a potential of more than one tenant. I can't believe that the 500 take it or leave it is right. There would be some sort of negotiation. Go back to the tribunal and sort it out. But to come back to the broader point, those hereditaments, like the National Trust, where it's shown that no tenant would take a tenancy at more than £1, have thereby been valued. It's not the usual course by which one can go about it, but it is the valuation. Any other valuation is going to assume a demand that doesn't exist. My Lord, I was beginning to dance, which is on page 343 of the core bundle you were taken here before the tribunals, the VO's statement of case in the tribunal. And 4 lines down, we read these words: these comparables establish that there was market demand there was market demand for the appeal property, and consequently, it had a substantial value. Those comparables are or include those that became the basis of the VO's concept of general demand. And at 6.2 of Mr. Hewitt's evidence, page 399, in seeking to, paragraph 6.2, in seeking to establish demand and value at the AVD, I shall refer to the lease and actual occupation of the appeal hereditament, first piece of evidence, and to numerous other hereditaments within the locality which are materially the same and were occupied. I shall refer to these comparables to establish that there was market demand for the appeal property, and consequently it had substantial value. Now, my learned friend asks, because in reality she has to, ask you to assume that that doesn't mean what it says. That he, Mr. Hewitt, was using the fact that those comparables were occupied and the rateable values at which they were assessed to establish there was market demand, not some hypothetical demand, but market demand for the appeal property. So
Why are we going back over that?
Because
it's agreed later on that there wasn't.
Indeed, but my learned friend was trying to paint to you that there had been no change.
But you say, I see, well, that doesn't matter for our purposes. What matters is what the position was as considered by the tribunal.
Indeed, but it colours quite a lot of what my learned friend says, and as I said to you earlier, it doesn't, in the end, form a critical part of what I have to say, but it does, once you have the correct colour, undermine in my submission quite a lot of what my learned friend has said. So the position about Hesketh House is being used as evidence in support of the proposition that it showed demand for the appeal hereditament. Now, we summarise relevant elements of Mr. Baldwin's evidence. He was the ratepayers surveyor in paragraphs 57 to 61 of our case, and footnote 25. In short, what we're saying there, or what he was saying, was that something fundamental had happened in the file. Paragraphs 57 to 61. For speed, I was proposing to summarise that something fundamental had happened in the file. The private sector had already abandoned aged office blocks like Mexford House. All agreed there'd been no demand from them, the private sector, at any price for Mexford House, and the public sector was making a fundamental shift. It's not a question of, oh look, 9 out of 10 are occupied, and someone will come along in a few minutes for the 10th. The public sector was making a fundamental shift. There were significant reductions in both the number of buildings and the floor space occupied. So, for example, HMRC in the area were reducing from 14 units to 8. And others, which are mentioned in Mr. Baldwin's evidence and in these passages in the case, were following suit. The broad proposition is at the bottom of paragraph 58 of our case in the period leading up to and immediately following the AVD, all available information from analysis of activity in the file points to the public sector estate downsizing and modernising. And perhaps this is worth turning up, as recorded in paragraphs 59 and 60 of our case, Mr. Baldwin's view was all of the evidence, including that about Hesketh's house and the others, led him to conclude that second-hand offices dating from the 1960s and 70s were either demolished, completely refurbished and redeveloped, or remained empty pending lease expiry. Once they were vacated, they were obsolete in his use of that term, which I take to mean effectively at the end of their useful life in their current guise. The next future is demolition, complete refurbishment and redevelopment, or that once lease expiry has died. Lease expiry has occurred. Now, if that were right, then as a matter of logic and evidence, then Mr. Hewitt's assertion that I took you to and you asked me why, that the comparables established that there was market demand for the appeal property, and consequently it had a substantial value, that assertion would be unsustainable. And as we explain in the case at paragraph 61 to 62, Mr. Hewitt did not accept Mr. Baldwin's conclusion. And could I ask your attention to paragraph 61? Mr. Baldwin had said, the evidence presented does not lead to the unequivocal conclusion that there was no demand for Mexford House vacant and to let within the rating hypothesis. Forgive me, I'm reading the wrong one. Paragraph 59, I'm grateful to my learned friend. Mr. Baldwin is at the top. The finding described in previous sections of this statement lead to the unequivocal conclusion that vacant and to let at the AVD there would be no demand for Mexford House. And the reason to take you to paragraph 61 is that Mr. Hewitt responded with the heading paragraph 11.1 is not accepted. So that was the major battleground on the evidence. As paragraph 24 of the tribunal decision records, may I ask you to turn that up? It's MS page 198. In cross-examination, Mr. Hewitt changed his position. And my learned friend, he recognised that as at the AVD, he couldn't identify anybody in the real world who would put in a bid. There was no such demand from the private sector. All public sector demand were being met by the occupation of other premises, which the public sector already enjoyed. He accepted the opinion expressed by Mr. Baldwin in paragraph 11.1, the one that previously had not been accepted, namely that vacant and to let at the AVD there would be no demand for Mexford House. So he's gone from saying there was a market demand for the appeal property, evidenced amongst other things by the occupation of Hesketh House and so forth, to saying on all the evidence, there wouldn't be a market demand for the appealed property at a positive rent.
When you say he'd changed ground, that was your interpretation rather than something the UT said.
It is also the tribunal's interpretation.
Did they say, where did they say he'd changed?
Strangely, you pick this up in the costs section.
Oh, that explains why I didn't pick it up before. Late concession.
This is page 221. And paragraph 113, my submission, referring to paragraph 31, Mr. Glover submitted that the reason why it proved possible to cast the hearing as a matter of law was the changed position that the valuation officer was forced to adopt in cross-examination. Until then, he had not accepted the proposition that were the appealed property on the market at AVD, nobody would have been prepared to occupy the appealed property and pay a positive rent, which Mr. Glover thereon referred to as the proposition. And if I could then ask you to turn to paragraph...
Well, paragraph 119, it looks as though it was being argued against you, but there hadn't been a change of position. But at no stage did the appellant try to argue that there actually existed in the real world someone who was prepared to pay for Mexford House.
That was the optimistic submission of the solicitor for the revenue. If we turn to paragraph 132, this is another submission from me in reply. Mr. Glover submitted that up until the point that the parties agreed the JPP, the appellant's position had been that there were two issues. First, whether at the AVD somebody would have come forward to rent Mexford House at a positive price. And second, whether the rating hypothesis required the valuer to assume a demand, even if it wasn't there. By agreeing the joint position paper, the appellant had abandoned the first point and relied solely on the second. That meant that Mr. Baldwin's evidence was accepted, confirmed by the fact that Miss McCarthy chose not to cross-examine him. And then on to paragraph 142, where finally we get to the tribunal's discussion of this. We are satisfied that the joint position paper was agreed as a result of the concessions which Mr. Hewitt made in cross-examination, and that the appellant accepted for the first time the basis of what Mr. Glover had called the proposition. It is clear to us that despite HMRC's solicitor's submissions on costs, the proposition was at odds with the position that the appellant was maintaining until that point.
It wasn't just an acceptance of the position on that day, the AVD, was it? It was an acceptance of paragraph 11.1, which had been the end point of going through the material showing the declining market.
It was an acceptance of what finds its way into the joint position paper, for which paragraph 11.1 is a workable proxy.
Yes, but I'm really looking at, there's been suggestions from time to time that all we're talking about is there is no actual tenant on that day.
No, we're not.
But this is actually the end point, 11.1, of a description of the declining market in the area.
Exactly, madam.
Sorry, 11.1 of what?
Page 461 of the, it's Mr. Baldwin, isn't it?
Mr. Baldwin's evidence, and the point that's being put to me, and which I'm heartily endorsing, is that 11.1 is a conclusion that Mr. Baldwin reaches after looking at all the evidence.
But it wasn't a conclusion about a day, it was a conclusion about a declining picture, which was on a trajectory, was it?
About a declining picture, which meant that at the valuation date, and every valuation for rating has to be done at that valuation date, not the following Wednesday week, but at that date, there was absolutely no demand.
Yeah.
Now,
can I try and put it slightly differently? It was a conclusion about the state of the market on that day, but not a conclusion about whether you'd got a bid on that day from a tenant. So a valuer asking about what the value is on a certain day may have to build in a certain time for marketing ahead of the day, and so forth.
My Lord, in rating, as I believe in, for example, death duties cases, one assumes that the deal is done on the valuation date. That's required. If the assumption requires you to consider pre-lettings and so forth, all of that happens in time for you to be able to do your deal on the valuation date. But the point about timing has, in my submission, two aspects to it. The first aspect is, as a matter of law, you value as at the valuation date. And that is required of you. That's part of the hypothesis you have to accept. You have to accept all of the hypothesis. You accept it because it's part of the hypothesis. However, if as a matter of evidence, Mr. Hewitt had been able to say, well, look, I know that on the 1st of April 2008, it was empty and there was no demand apparent. But 3 weeks later, 4 months later, 2 years later, something came forward. Then your decision-making body is going to ask itself, does that evidence tell me something about how to reach a conclusion about what the level of demand was at the valuation date?
And the point that my lady made a moment ago about evidence of a declining market is something that the valuers on both sides would have a range of rental figures, and they would see if the rents being struck in the real world were declining over time and evidencing a declining market, and they would then, take that into account in arriving at the appropriate per square metre rate for offices in the area on the valuation date.
My Lord, I may be wrong, but I think my recollection is correct that there was no such bounty of evidence in this case on which the £59...
Well, that may be, but in that event, if all the evidence comes from several years earlier, for example, rents struck some time before the valuation date, it will then be a matter of judgment by the valuers on both sides as to how to adjust those in the light of their perception of how the market was developing.
Indeed, and how lucky they felt about taking the case to the tribunal. But what we have that is unusual here is the view initially adopted, or throughout adopted by Mr. Baldwin, subsequently accepted by Mr. Hewitt, that in the real world there could be shown, it's not a doubt or an absence, an inability to show a presence of demand. It is an ability to show an absence of demand above £1. And Mr. Hewitt is not saying, well, I agree that point, were it not for the occupation of other premises. I would conclude there was no market demand. He was not saying, but for the occupation of the other premises, I conclude there market demand. His agreement is uncaveated. And that's why it was a significant step forward. It was in the light of that concession that the case then took the course it did. And as we saw, I think with my learned friend, at paragraph 31 of the tribunal decision, MS page 200, the parties informed the tribunal that having regard to Mr. Hewitt's concessions, particularly the matters referred to in paragraph 24, it could proceed as a point of law. Both parties were saying that what was revealed and recorded meant that there was no remaining issue of fact or judgment. What remained was a point of law. An end to this takes me, if I may, to paragraph 26 of the Court of Appeal judgment, page 149, where Lord Justice Henderson is referring to that part of the tribunal's decision where they say, well, if you're going to follow the JPP route, there are some questions we'd like to ask, but that we won't be able to. And at paragraph 26 on that subject, Lord Justice Henderson has this to say. The answer from Miss McCarthy that those points weren't relevant and that the valuation officer did not seek to argue that in the real world Mexford House could at the AVD have been let at a positive price, with the consequence that those points didn't need to be investigated. This answer reinforces the agreement contained in paragraph 3 of the joint paper and makes it clear beyond argument that the assumed position now was that, as at the AVD, nobody in the real world would have been prepared to pay even a discounted price to occupy Mexford House, including the current occupiers. And incidentally, they were only current occupiers because they were taking time to move out. So, if the valuation officer was to get home at £370,000 rateable value, it would have to be despite the agreed conclusion on all the evidence. And as the evidence all led to the conclusion that there was no demand to occupy the appeal hereditament at a positive price, the only alternative source of a demand to occupy at a positive value would be if that were required by law. In other words, if the law required you to assume a demand that did not in reality exist. And that is something of which the upper tribunal itself was fully aware. If I could ask you to page 160, MS page 160, this is the tribunal giving permission to appeal. The appeal raises an issue of principle which is likely to recur in connection with substantial vacant buildings with significant notable values. Where the evidence shows that there is no demand to occupy a hereditament which is capable of occupation, does the rating hypothesis require the valuer to assume demand that does not in reality exist? That, I took you to the JPP earlier, is, in my submission, also what the position paper provides for on its face. And that is also the question which the Court of Appeal decided. There was, in truth, no other issue. And it's at this point that the position becomes even more odd. If I can ask you, please, to pages 19 and 20, in MS pages 19 and 20. This is part of the valuation officer's application for permission to appeal to this House. I ask you to paragraph 27 on page 19. This is actually in the information. Paragraph 26, the VO doesn't agree that formulation. Paragraph 27 says that the formulation omits 2 points. First, it omits the important limitation that the evidence was as to demand on as at the valuation date only. I'll come to that. But secondly, and this is why I've brought you here at this stage, it was no part of the valuation officer's case that the VO should be required to assume demand that does not in reality exist. The statute requires a hypothetical tenant to be assumed, not an actual tenant. In valuing the hypothetical tenancy required by statute, the VO's case was that evidence of value can be taken from comparable properties in the locality which were occupied at positive rents as at the 1st of April 2000. So, unless things have changed, we are agreed that the rating hypothesis does not require the valuer to assume demand that does not in reality exist. The valuation officer is concerned only about what evidence can be taken into account. But the JPP doesn't exclude the evidence that the valuation officer wants taken into account. All it does is say that evidence is not necessarily decisive. It's a piece of evidence to be weighed with all the rest. Well, those are my submissions on that point.
Can I ask you, one strand of your argument really pins the appellant to the wall on the basis of the terms of the JPP. There is, in the Court of Appeal, I think also a view that as a matter of law, the appellant was going to fail, particularly in paragraph 43, which is on MS 154. Where, if you look, it's perhaps best encapsulated in the last sentence. In a saturated market, there is still a proper basis for a substantial rateable value while the existing tenant remains in occupation and pays substantial rent. But that situation changes once the property becomes vacant, because there's no longer a potential tenant available to take it on the statutory terms required by the rating hypothesis. That, as I understand it, sir, a proposition about rating law, which doesn't depend on the terms of the JPP.
It is a proposition that does not depend on the terms of the JPP.
Yeah.
It is also a proposition on which the decision in the Court of Appeal does not depend.
Yes.
Yes, I mean, is it a proposition which you would support?
I say that it's incompletely phrased.
Answer no.
If I may explain, what I suggest is happening here is that the tribunal, that the court, forgive me, is giving its ratio in paragraph 41. And I note that actually nowhere in my learned friend's case is issue taken in paragraph 42 comments briefly on the factual circumstances in which the JPP came about. But it is not, I'd say, incomplete. And this is where the point about market saturation first comes in. In other words, the relevant market was saturated. That is true, but it's incomplete as a description of what led Mr. Baldwin to his conclusion that vacant and to let, there's just no way you were going to find anybody who'd give a positive rent. It was partly that the market was saturated. It was also partly that the public sector were contracting and moving out. Now, if one were to then say to a tribunal, have another case in which you can see that there is an excess of supply over demand, looked at over the whole of the market for some type of space, that, if anybody is going to take my argument in those circumstances, he's got an evidentially much more difficult road to hoe than I have in a case where it's not just a matter of market saturation, but it's a matter of absolute contraction. And so my foot-to-foot answer really is to say that it may well not be right on all the evidence. It probably isn't right on all the evidence to say whenever you are able to describe a market as saturated, as a matter of law, there follows some sort of conclusion that it's a nil rateable value. I suspect that one of the preconditions of being able to make the point that on all the evidence we say was made is that the market is saturated. So in truth, I'm saying that what you have always is a matter of evidence and judgment. The assessment is economic, not one of law. So to lay down a proposition, if what Lord Justice Henderson is doing, and I don't think he is, but if what he's doing is to say, whenever you can use the phrase saturated market, quite whatever that means, then the result has to be, as a matter of law, £1. I say, no, well, that's an area to which the law doesn't go at all. The law leaves that to valuers and their judgment.
I suppose you could take a simpler example than this. You've got a football stadium in a town, and the town has a single football club which is in occupation of that stadium. For rating purposes, you have to assume it's vacant and ready to let, which you've got a lovely tenant called the local football club who will be very happy to take it. If, on the other hand, the true position was that the tenant had just gone into administration, and let's say without any prospect of being rescued, so that there wasn't, in fact, going to be a football club in that town, the consequence of the property being vacant for that reason could have a radically different outcome in terms of the rateable value.
Even that would have to be looked in the context of all other evidence.
Absolutely. No, I'm just trying to come to a simple example to focus on the point.
But in those circumstances, then your ratepayers clearly got a chance on the evidence. My lords, there are, I've got 3/4 of an hour. There are 2 points that I particularly want to call for your attention. My lady. Sorry, thank you. So old-fashioned to have such a big file. Oh, is it because... Okay. The first is assumptions about tenure in the rating hypothesis. And can I take you to the case of my learned friends at their paragraph 86. and they take two propositions from that. One is that one must assume that all properties, as well as the one subject to valuation, are held on the statutory terms.
Sorry, we're at...
Paragraph 86, MS page 81.
Thank you.
Two propositions. One must assume all properties are held on the statutory terms. And two, accordingly, the occupiers of other properties should be considered potential tenants of Mexford House. We say, in global terms, that the first of those propositions is incorrect, and I'll expand upon that. But in any event, the second of those propositions does not follow from the first. It's a simple point. There is no evidential justification for concluding that had the occupiers of, for example, Hesketh House been on a tenancy from year to year rather than whatever tenancy they were on, they would suddenly have made a bid for Mexford House. You certainly don't get that from the JPP. There isn't any evidence. Well, given that the tribunal confined itself to a question of law, there isn't any further evidence on it.
Do we know what sort of tenancies the other properties like Hesketh House were on?
Not off the top of my head.
Don't take time over it.
I'm reliably informed, and thanks to both, that Hesketh House was on a lease of 62 or 63 years. In the event, whatever one says about Proposition A, its linking to what I've called Proposition B is no more than another attempt to use the hypothesis to create a demand, to create potential hypothetical tenants that didn't in reality exist.
It's more create hypothetical tenants on the relevant terms. I mean, the point old Briggs is making, there's one thing having a tenant who's stuck with a 60-year lease, can't get out of it. It's another thing to say that whether he would be prepared to make a bid for a yearly tenancy of a different comparable property.
It is a question, but it is still involves assuming a type, or considering the possibility of a type of demand that did not exist in the real world.
Yes, I was really thinking of the way the upper tribunal put it at paragraph 1. Where they talk about the sort of assumption that because there are other occupied premises, therefore, let's assume they're available to occupy. Yes, it's 106, the reference to the general demand for such properties as evidenced by occupation of other office properties with similar characteristics. But of course, one's got to take into account that they're occupied on different terms and where the tenant can't get out of them, arguably so.
Well, look, put yourself in the position of the ratepayer.
I mean, it's a point, if it's a good point in your favour, rather than against it. Yes, it's really 102 at the bottom. There's no reason to conclude that the public sector occupants of those comparable premises not already accommodating those premises would not have been unable to enjoy beneficial occupation of Mexford House and find that occupation of substantial value. I'm just wondering whether that isn't making an assumption about the terms on which they would be willing to do it.
All I say that is saying is Mexford House is capable of beneficial occupation. If the world were different, people could use it, but nobody wants to, for very good reason.
Presumably valuers in this context, where they're doing a yearly tenancy valuation, are constantly having to make adjustments from market comparables, because I suppose there probably aren't all that many yearly tenancy comparables as such.
My lord, the answer to that comes in two parts. The first part is that as we only have 5 yearly revaluations, although it may turn to 4, they're only doing it occasionally. And the other more fulsome answer is that, as you will have seen from Humber and Jones, for example, what they do is work from real life rents and ask themselves whether the rating hypotheses, assumptions about duration of the tenancy, which is not simply on the law, it's a tenancy from year to year. There is an expectation of continuance, a reasonable expectation of continuance. And in the retail field, for example, valuers have come to the conclusion, endorsed by the tribunal quite some time ago now, that in effect, if you've got a 3-5 year rent review, there is nothing that the tribunal can concretely put its hand on to say that the tenancy from year to year would have a different value. What happens if you've got a 15-year lease? Then, yes, the rent will be adjusted to reflect that, because that's reflecting 15 years rather than the more common turnover.
Yeah.
And indeed, that's what Humber and Jones really is about. There's a factory which it takes 5 years to tool up for. And if you're on a tenancy for year to year, just taking that on its face, no one's going to take it. But the courts say rightly, look, there is clearly a demand, Humber are there. You can't use the hypothesis to artificially remove that demand. Instead, you must so arrange your assumptions that that is allowed for. And in Humber and Jones, the tribunal thought there really isn't that much difference, given all the circumstances between the lease they had and the likely duration of the hypothetical tenancy. In railway cases, Southern Railway, no one would take a tenancy of a railway if they've got to potentially sell all their rolling stock at the end of the year. So the assumption is made that that's not going to be a problem. It's going to be easy to acquire as to get rid of. But those are all cases in which the courts are making sure that the hypothesis is not being used to pretend that there isn't demand to occupation that isn't really there. But back to tenure, the first thing I say is that the rating hypothesis on its face does not require you to assume that other hereditaments are on a counterfactual tenure. The fundamentals of the approach that you shouldn't depart from reality unless the hypothesis forces that you're looking for the rent of this particular property, that you keep counterfactual assumptions to the minimum, all, in my submission, weigh in favour of not making this unnecessary counterfactual assumption. And my learned friend, Mr. Flanagan, took you to what the Court of Appeal had to say on this subject in National Trust. And I simply say that if it is right to assume that the National Trust has the ability to acquire other properties at a freehold, on a freehold tenure, there's no reason to assume that other people do not. I should just, in giving those examples of cases where the courts reach a decision, the purpose of which is to avoid the hypothesis distorting demand. I should draw your attention to Poplar and Roberts as well. The Rent Restriction Act soon after the war meant that although a tenant might well be prepared to pay a rent above the Act's maximum, the Act prevented the landlord from demanding it. And the House of Lords decided that that feature is not one that should suppress the rateable value of a particular pub in Poplar. And the point is that the demand, as evidenced, was prepared to pay more than the ceiling imposed by the non-rating legislation. And so this was just another example of the ratepayer trying to use something to distort the real-world level of demand and the rent that it would pay. The common theme of all of these cases, my lady, my lords, is that attempts to use the hypothesis to gainsay the effects on occupational value of demand observable in the real world were all thwarted. None of them, I say, provides any warrant for the reverse proposition, namely that the hypothesis can be used to fabricate a type or level of demand observably absent from the real world. As to Humber and Jones, there are 2 points, one broad and the other particular on the words of Lord Justice Wilmer. This is Authorities Volume, second Authorities Volume at tab 25.
Page?
967.
Page 2, starts, my note, forgive me, is on the internal numbering. So MS 969.
Okay.
And the right-hand column justifies these propositions. Although in the real world no tenant would rent a car factory from year to year, especially one where tooling up took that 5 years, the tribunal considered there was virtually as good a prospect of security of tenure under the rating hypothesis as under the actual lease from which it had derived its starting point of valuation.
Sorry, I haven't found this.
Forgive me.
969 second.
Page 969, I said second column. Forgive me, I should have started at the bottom of the first column. The description is that the valuation, the tribunal started from a rent of £70,000. There had been some actual rent. There's some dispute about that, but we can pass over that. And at the bottom of the left-hand column, 295, trite laws say all these cases must be decided on their own facts. Here there is a landlord, the minister, and the tenant. The matter has to be considered on the basis that according to the conclusion which the tribunal reached, there was in this case virtually as good a prospect of security of tenure on a year-to-year basis as under a lease for a term of years. That's Lord Justice Hodson. And as a result, the tribunal did not abate the £70,000 rent. If one then does go to the right-hand column, the ratepayer didn't, and this is the first full paragraph, the ratepayer didn't argue that as a matter of law, the rent of the hypothetical tenancy would necessarily be less than on the term of years. So as Lord Hodgson noted, he had a difficulty in formulating a point of law, but he lit upon one sentence of the tribunal that Lord Justice Hodgson quotes, the second quotation in the right-hand column. I agree that in the everyday world, the tenant of a factory such as this would not consider for a moment a tenancy from year to year, but rating is not the everyday world. It's the domain of a hypothetical tenant who is faced with the fact that, try as he may, he can't become the owner of the premises he occupies. Neither can he get a lease for a term of years, short or long. Then there's a reference to South Staffordshire, which is one of the cases about the duration of the hypothetical tenancy. I draw attention to the fact that the way in which the tribunal put this is that he wouldn't be satisfied that the rent offered and accepted in this hypothetical world would differ materially from the actual rent as agreed. Prima facie, that is a finding of fact. And indeed, that's what the Court of Appeal concluded. Lord Justice Wilmer agreed and in doing so, bottom of page, right-hand column of 296, top of 297. The fact is that it's impossible to get away from the situation that the statute postulates not only a hypothetical tenant, but also a hypothetical landlord. And as the tribunal said in the passage cited, in the context of a hypothetical world in which the hypothetical tenant cannot become the owner of the premises and cannot get a lease for a term of years. So far, so uncontroversial. Moreover, one has to postulate a world in which not only this hypothetical tenant is in that position, but everybody else is in the same position. In the end, therefore, we are in a world of make-believe. What the value of premises in such an imaginary circumstances would be seems to me to be very much a question of fact. Always amused by that final sentence.
He's not, in fact, looking at other properties and saying we have to assume that,
Exactly so.
insofar as relevant to market demand, they're all held on the same terms. He's just saying that anybody bidding for this property.
Yes, that's my point.
Think.
Well, that's my submission, I can't won't make it better by repeating it. The next case is not actually, in anybody's language, an authority, because it's in the tribunal, but we need to just look at it on the way to Barrett International, if you'll forgive me, because it's referred to in Barrett. And that's Wyre Forest, which is Authorities, Volume 2, tab 25, no. 34.
Page?
1113.
Thank you. 1113.
The first reference is going to be on page 1119. This concerned the valuation of council housing. The rents passing were agreed not to be at market value and as no assistance. They were actually assessed so as to make sure that the housing account ran at even. And Poplar applied. There was evidence of market value rents, and the Ratepayer Council's valuer said, and this is, I'm taking this from the first large paragraph on the top of page 1119. He said there were 1,200 council flats or maisonettes, that there were 150 flats or maisonettes that were let on the open market. This is in Kidderminster. If, he said, all the council flats and maisonettes were available in the open market, that would increase the supply of open market units and could reduce the open market value from that which the evidence showed. Now, my submission, the premise is false. You are not valuing 1,200 council flats. You are valuing one council flat on each one individually. So the market in which its value is to be assessed is as in the real world, save that one assumes that the subject arrondissement is vacant and to let. So there never is a flooding of the market that the ratepayers case envisaged. Nonetheless, without deciding the issue, and the VO wasn't legally represented, the tribunal decided that even were the ratepayers' assumption correct, it didn't, on the evidence, indicate any market value rental. The task is to identify what would be the general level of value if you assume the altered state. That's because you're not in a case like ours, where there's an unusual demand, but where you're looking at the general level of demand because your general level of rent, because the evidence doesn't show a difference in levels of demand. So if you assumed the ratepayers' altered state, that all of the council flats were available at market rent, not only would all of those units be available to rent, but their tenants would be paying open market rent on the evidence according to the tribunal. And so the evidence did not disclose that the world that the valuer for the ratepayer sought to construct made any difference in the event to the generally perceived market rent value. What was happening here, in other words, I say, is that the ratepayer was trying to use the hypothesis to create a counterfactual balance between supply and demand by loading, in this case, the supply side. That's also what's going on in Barrett. Which is at tab 20 in the same bundle. And the facts are at page 863. Actually, the point that interests us is not the main point in that particular case. It was a subsidiary point. The main point was when, if you're valuing timeshare units, do you compare by reference to dwellings or to holiday cottages? And the reason it was said you didn't refer to dwellings was that they were now subject to council tax. And the court said, well, that makes no difference. If they're the best comparator for value, they're the best comparator for value. But 89 individually assessed timeshare units valued on the comparative basis. The point raised by the valuation officer derives from page 871. Towards the bottom of the page, about a third of the way up. One of the 2 points, subsidiary points. Counsel for the ratepayers first argued that the tribunal had erred in failing to make a deduction from the net annual value calculated on either basis, on account of the fact that if all 250 of the timeshare units in this case were to come onto the market for letting, that would depress the rental value. Again, I say the premise isn't right because you're valuing each one of them individually on the assumption that everything else is as it was. Lord Gill's response in principle is on the next page, at the top of the first full paragraph. In essence, the submission for the ratepayers on this point repeats an error that was identified in Wyre Forest, hence I took you there. It involves a hybrid approach to valuation in which the supply is assessed in the hypothetical world, but the demand is assessed in the real world. That, in my view, is an unwarranted approach. And I'm not aware of anybody trying it on since Wire Forest. Again, in my submission, the aim is to avoid a counterfactual imbalance between supply and demand. Now, his particular course of doing that is in 4 propositions on the previous page. The first, in valuing to net annual value on the statutory hypothesis, the assessor and this court must assume that no one holds lands and heritage on any tenure other than a letting on the statutory terms. The second, in this hypothetical world, the proprietor of subjects is assumed to be a possible tenant of them. The third is one ought not assume that in such a world owners, occupiers and owners of timeshare interests would not be potential offerers for the tenancy of the subjects under the valuation on the statutory terms. In the hypothetical world, one assumes the demand is available to meet the supply, see ride. The second of those propositions, in this hypothetical world, the proprietor is assumed to be a possible tenant of them, is not controversial. The first, as we've seen from Hoare and the National Trust, is not the position currently adopted in England. And for reasons that I've already explained, we submit it's not an approach that should be adopted.
Sorry, which one is that?
I do beg your pardon, my Lord.
You said the first. I wasn't quite sure which proposition.
The first proposition, forgive me, of course I've marked them on my paper, but I didn't ask anybody else to do the same. In valuing to net annual value, the assessor must assume that no one holds lands and heritages on any tenure other than a letting on the statutory terms. As I said, I took you to the National Trust and say that on that authority, that's not the position at present in England, and for the reasons that I've already expanded upon, it shouldn't become the position in England. The final 2 propositions, one ought not to assume that in a world such a world, owner-occupiers wouldn't be potential offerors, and in the hypothetical world, one assumes that the demand is available to meet the supply, need to be taken together. The context is whether, and we're now, my Lord Conworth, somewhat covering the ground I responded to you earlier on. The context is whether a general level of value should be suppressed as against that shown by the real world evidence, on the back of an assertion that the rating hypothesis assumes an increase in supply against the real world. In that context, the answer is given by the reference that Lord Gill refers to in Ride, and which we have quoted in our case at paragraph 137. That can't be right. Do forgive me. No, it is right. It is right. I had the wrong document that didn't come to paragraphs 137. Forgive me. This is the extract from Ride, as we're pretty confident it was at the time Lord Gill was looking at the case, because this appears both before, in earlier versions that predate him and that postdate him.
Sorry, where do we find it?
Page 127.
MS 127.
MS 127.
Oh, yeah, sorry.
Entirely my fault.
From the core one.
And it's Ride's comment on Wire Forest.
Thank you.
And I was saying, because there is a paragraph 254 from Ride in the authorities bundle, but that quite clearly post-dates and includes text that wasn't before Lord Gill, that we think it's more appropriate to look at what was in existence both before and after his pronouncement. And it refers to Wire Forest, and I might ask the court to read the whole of it at what we can laughingly call your leisure, but at the bottom of the page we have these words: if the assumption were not made, not only the supply, it's saying the Wire Forest found it the tribunal found it unnecessary to decide whether it was necessary to make the assumption that all properties are available to let on open market terms. If the assumption were made, not only the supply but also the demand for property on those terms would be increased, since all the occupiers on other terms would be in the market, and it was not shown that in those circumstances the general level of open market rents would be any lower than they were in fact.
So far from that, therefore, that last proposition being an assertion that one must assume that there is always an equivalence between supply and demand. You say on teasing it out, it just says you shouldn't use any of the hypotheticals to distort the balance of supply and demand in the real world.
That is my submission, my lord, yes.
It's a very odd way of putting it.
Yeah, the way the tribunal put it in Wire was that the fallacy was in assuming that the total amount of money which people were prepared to pay as rent for flats and maisonettes in Kidderminster was fixed by the properties that happened to be let at the time of the valuation date. Because on the valuation hypothesis, you were assuming that Mr. Eves' submission had been correct, you were going to have a vastly increased number of people in the market for rented property.
Yes. That is the basic point. There is perhaps a grace note on it, which is that if one thinks about it, one might say, look, actually, those people who are brought onto the market by that hypothesis are council taxpayers who may well not be sufficiently wealthy to pay the higher market value. And so there would be some sort of effect. But the interesting thing is the tribunal's approach there, it was the same tribunal approach as we still see today, was essentially that unless you're able to prove to me that that proposition does follow, I'm going to follow the market and the evidence that I've got. So unless, moving it to our case, you're able to show that there really is no demand to pay anything other than £1, I'm not going to be persuaded of it.
Yeah, but I mean, clearly Lord Gill regarded it as a clever valuer trying on a rather ingenious idea and not getting away with it.
And this is a way of solving
that. He said no one's tried it since.
This is a way of solving that narrow problem, but it wasn't done considering the wider sets of circumstances that we now have. It wasn't in any, as I said, I think earlier, Lord Gill, my submission, would be very surprised if anybody thought he was saying you should distort balance between supply and demand. The other matter that I wanted to make sure that I did cover in time was, in truth, the remainder is, I hope, sufficiently clear from our plump case. It is the common yardstick point and Ash Brothers and Heaton. And the proposition here is nobody ought to be suggesting that you should sacrifice correctness to uniformity. That's the first point. And the second point is, in deciding what uniformity is, you can't pick and choose the characteristics you're going to look at. Now, I recognise that in any comparison of value between two assets, there are more considerations that come into it than I'm about to put to you. But in my submission, where the evidence shows demand to occupy one hereditament at a positive value, and the complete absence of demand to occupy another hereditament at a positive value, the doctrine of uniformity ought to follow rather than buck those facts. Now, it's not as though what's happening here is somehow the absence of occupation, the vacancy of Mexford House, is giving it a leg up in some way. If you're valuing Hesketh House, you do so vacant and to let, but you know that there is evidence that the NHS is using it, and you're going to have a pretty difficult job as a ratepayer saying that there is no evidence of demand for Hesketh House.
In fact, there was an agreed rent review close to the valuation date.
For Hesketh House?
Yeah.
Indeed. I'm not sure whether it was, I think most of them were upward only. I don't know whether the review was upward, but indeed. But the point is, it's not the presence or absence of vacancy that's driving the conclusion. What's driving the conclusion is that the evidence shows that there is a demand, or at least means you can't show there isn't a demand for one, but you can show there isn't a demand for the other. Now look, as for Ash Brothers Heaton, we may need to turn this up. So, intriguingly, not a case that my learned friend even thought it worth putting before the Court of Appeals, if as I can recall. It's in the primary authority at volume 1, and behind tab 3,
Page 546.
Page 546. My Lord, the case is about an attribute of the hereditament. Large factory building, a corner of which was the subject of a confirmed compulsory purchase order. And the expectation was that that compulsory purchase order would be activated and a piece of land taken within about 8 months, I think it was, of the valuation date. The evidence was that the hypothetical tenant, if he took into account the fact of this likely imminent acquisition by authority, would offer for the whole a somewhat lower rent than if he didn't. So the case is nothing about demand at all. Indeed, there are other places that I might take you, both in this case, I think, and certainly in, for example, Robinson Brothers. But could I ask you to Lord Pierce on page 562? So perhaps I should complete the point by starting earlier. At 561 at H, rating sets a standard. Out of various possible standards of comparison, it's chosen the annual letting value, and therefore has to estimate the rent at which the hereditament might reasonably be expected to let. This standard, the rent at which the hereditament might be expected to let, is universal, so you apply it to every hereditament, but it's more difficult with some than others, sewage works, railway lines, and so forth. One must assume a hypothetical letting in order to do the best one can to form some estimate of what value should be attributed to a hereditament on the universal standard, namely a letting from year to year. So that's all consistent with all the cases we've been looking at. You apply the same test. What would this hereditament rent at? Measuring the supply and demand, Robinson, and so forth. And he happens to express that by saying that involves ignoring some human realities. And really what he's saying is one ignores those realities that are get in the way of applying the rating hypothesis. So he then goes on to say, but it only excludes the human realities to a limited and necessary extent, since it is only the human realities that give any value at all to the hereditament. In my submission, one of the human realities you do not ignore is the level and nature of demand. Because that quintessentially is one of those human realities that give any value at all to hereditaments. And you assess that by reference to the evidence. And if, as a result of that, you come to the conclusion on all the real-world evidence, the highest value is £1, then it would be contrary to the principle of uniformity artificially to increase that rental value, because there is something different between that hereditament and any other hereditament that is valued at a positive value, and that is the level of demand is different. My lords, I could say more, but as I said, most other points, I believe, are covered in our written case. Yes. I'm knocking up on my time. Unless I can assist further, those are my submissions.
Thank you very much, Mr. Glover.
Thank you.
Ms. McCarthy?
Thank you, my lord. I have various discrete points in reply. The first, if I could simply just state without turning up the passages. First of all, paragraph 11.1 of Mr. Baldwin's evidence, we say, was not a conclusion just as to the state of the market. It was about the actual tenant, the actual demand for Mexford House. And it took into account his opinion that it was too big, too old, the wrong location, etc. My second point, the upper tribunal at paragraph 29, and if I could ask your lordship please to turn this up, so this is core volume, upper tribunal, MSK 168. Paragraph 29 sets out that he, being Mr. Hewitt, considered that the existence of demand for such other comparable properties, which he referred to as a general demand, demonstrated that there was, for the rating hypothesis, a sufficient demand for Mexford House. So it is not the case that Mr. Hewitt conceded that for the rating hypothesis there was no demand for Mexford House.
Sorry, I didn't hear that.
It is not the case that Mr. Hewitt conceded that for the rating hypothesis, there was no demand from Mexford House. It's simply that in the real world, the market was saturated, and those are two very different points, and we need to be careful about which we're talking about. If I could ask your Lordship then please to turn on to where this is reflected in the upper tribunal's decision. So paragraph 102, and this is MS page 187. The upper tribunal is then proceeding on the basis...
Sorry, can I have the reference again? I'm sorry.
102, page MS 187, paragraph 102.
Thank you.
The upper tribunal is proceeding on the basis that there existed several broadly comparable offices, and then there is the last sentence, there is no reason to conclude that public sector occupants of those comparable premises, if not already accommodated, would have been unable to enjoy beneficial occupation of Mexford House and find such occupation of substantial value. And we say that in substance and effect, this is contrary to a finding of obsolescence by the upper tribunal. So the upper tribunal cannot be taken to have signed up to obsolescence. I would also refer to paragraph 106, please, where the upper tribunal determines, 4 lines down, this rent would be negotiated between the hypothetical tenant and the hypothetical landlord by reference to the general demand for such properties as evidenced by the occupation of other office properties with similar characteristics. So in effect, the upper tribunal is signing up to Mr. Hewitt's approach in relation to the rating hypothesis. And of course, the joint position paper doesn't bind us to what is going on in the hypothetical world. It is simply a statement of the actual world. My third point is the fact of the declining market, and so public sectors vacating, is already taken into account and built into the £59 per square metre with regard to Hesketh House as at the 1st of April. And if general demand can be taken into account, we say that you simply read that value across to Mexford House, and it already reflects the declining market. So there is no other reduction in value that needs to be made to the 59, because that 59 is already reflective of the public sector's movements.
I think actually he took a figure, I think, of £71 a square metre for Hesketh House, which was itself a discount from the actual rent agreed at the 2008 rent review.
So the actual rent for Hesketh House was almost £71,
yeah.
And £59 was the agreed rateable value.
Yeah.
If I could now turn briefly to the Court of Appeal judgment, please.
Can you just help me out quite been puzzling me a bit? There's 2 copies of the decision in my bundle.
Yes.
And I seem to be sort of working miscellaneously from both. Why have we got one which starts at MS 163 and one which starts at MS 19?
So the only difference with the second is that has the costs addendum. And I think...
Well, they're set out differently. It's just that I've found that I've been marking one of them some of the time and the other one, which is why. But you say they're identical, are they?
They're identical. The substance of the final decision is identical. It's simply that the second one has the costs addendum tacked onto it. The words are the same.
But they're sort of laid out differently, so one finds different things on different... Anyway, there we are. So they're identical.
Yes, I apologise, my lord. Unfortunately, it's a little inconvenient how that's been put together. Turning to the Court of Appeal judgment, then, please. Paragraph 43. So this is MS 154. And just picking up on my Lord Reed's question that he put to my learned friend, The last sentence of paragraph 43, and I think the question was, is that not essentially a proposition of law being posed by the Court of Appeal? We say, yes, it absolutely is, and you can see that, first of all, from paragraph 43, just between E and F, where Lord Justice Henderson, in telling us why it is we went wrong, says, secondly, they gloss over, and then this, the critical point on the facts, which is the saturation of the relevant market and the absence of this real-world tenant. So Lord Justice Henderson considers saturation of the market to be the critical point. The other passage to go to is, in conclusion, paragraph 51, MS 156, right at the bottom of MS 156, the sentence starts, if, then it goes over the page, if there is no such demand, because the market is already saturated, the rating hypothesis cannot itself be used, and their words, to manufacture demand. And the reason for showing your lordships this is it is our case that Lord Justice Henderson determined the point of law that market saturation equals nil rateable value. And he was wrong in that. And once that is accepted, then it is plain to see that the Upper Tribunal's decision is right on its terms. My next point, then, please, is to do with the wording of the JPP. And I just want to say this. If the agreement that led to the wording was anything other than no tenant on that day, then the agreement would have been phrased no tenant from that day onwards. If we were signing up to something that is so radically contrary to our case, it would have needed to have said so expressly. And it does not read that it is agreed that there shall be no tenant from that day onwards. That is not what we were signing up to. We cannot be taken to signing up to something that is so different in substance to the entire basis that we'd put our case up until that point, especially as we'd made it clear that if the property had reached the end of its economic life, we wouldn't be here, because we accept no rateable value. Just a brief point in relation to Barrett. So this is Lord Gill at MS 871, just for your lordship's note, where he says, in valuing to net annual value, the assessor and the court must assume that no one holds lands and heritages on any tenure other than a letting on statutory terms. We say that's correct, because what is being said here is the equivalent to, you must disregard the accidental characteristics that exist between real-world landlord and tenant, so, for example, the actual contract. So we do sign up to that wording, and where this brings us to is that the tenant base, if I can call it that for Mexford House, is public sector occupiers of comparable properties. That's the tenant base. And one must ask, well, if they were free to take up a tenancy, how much would they pay for that tenancy of Mexford House? And we say by the time that it's been accepted that Mexford House is comparable to Hesketh House, you reach the figure of 370. We are not distorting supply and demand. We are taking into account all supply and all demand and applying the actual balance in the market at large. My next point is, we know that you have to assume a willing hypothetical tenant. In assessing the value, that person must have regard to the balance of supply and demand in the market generally. And we say that the principle of uniformity in the common yardstick results in our case of a general assessment of demand at being just falling below supply. That is the assessment of demand in the marketplace. So if you're to turn this notion of out of 25 comparable properties, 24 are unoccupied into a measure, we're talking about a measure, it's not really quite correct to say this, but we're envisaging a measure of 96%. That's the proportion. That's what general demand is. General demand is not, well, you 24 over there and us over here, there's no demand. That is not what general demand is about. And if we were to measure demand by reference to you over there and us over here, then you end up being totally contrary to the principle of uniformity, and that is forbidden. So all that demand in the marketplace is on about for rating purposes is, in our case, if we were to turn 24 over 25 into a percentage, this sort of notion of 96%, that figure that applies equally when you come to assess the value of all of those 25 hereditaments. That was the balance of general demand when assessing Hesketh House at 59, and likewise needs to be applied in the same way to Mexford House. We are not saying that general demand trumps something else. Rather, we are simply saying that general demand is one of the factors that the valuer must take into account, and which encompasses or embodies the balance of supply and demand for property of that type. Moving on to my next point, this is paragraphs 2 and 3 of the joint position paper. All that these paragraphs are saying, and all that we have signed up to, is as at the AVD, you couldn't get a tenant for Mexford House in the real world. That's it. That is the only factual proposition that we are signing up to. Now, it's important to recognise that that is not the same, as sometimes my learned friend maybe accidentally lapsed into, as suggesting that we have agreed that Mexford House would let at £1. That is not the same proposition. My learned friend has recast our agreement to allow him to say, well, if we've agreed Mexford House would let at £1, then general demand is already embodied in this notion of Mexford House letting for £1. But that is not what we have signed up to. So in us saying in the real world you couldn't get a tenant, that in no way takes into account any general demand whatsoever. It's a statement of bare fact and nothing more than that.
I mean, the problem seems to be that what you've said in paragraph 3 of the JPP has been treated as if you had said that there would be no demand for the property, and since value is a function of supply and demand, the implication is drawn that the inference is drawn that there's no value.
And this is why I think we need to be careful about. We're not saying, well, it's those 24 over here and we're the unlucky 25th, and that's how you measure general demand. Demand is, well, it's a proportion, this 96%, I appreciate that's not quite right, but it's 96% applies equally to everyone. It's not some treated differently to others. That brings me on my penultimate point, if I may. Lord Briggs's point just before the short adjournment. If one's looking at what the valuer may do in real life, at the valuation date, the valuer doesn't say, well, no tenant today, not worth anything. Otherwise, you'd have all these properties on Rightmove and any other internet, all worth nothing. Rather, the prospect today of me letting in due course is reflected in the figure that the hypothetical landlord is prepared to accept. Now, that's not talking about, well, what's the value of a tenancy 2 weeks down the line. That is saying, take into account the prospect today of a future happening. And that was essentially what Lord Pearson was envisaging in his reference in Dawkins and Ash. So just for your note, this is at 393 F to G, MS 573, when he said a present probability of a future happening, and the present probability affects the present value of the hereditament. The present probability of a future happening is today's real world. It is today's real world. So when my learned friend goes to all the authorities that say you mustn't depart from the real world, that is a feature that must be taken into account in today's real world. And we say that that is a feature that the Court of Appeal essentially shut its eyes to. It's shut its eyes to the present probability of the future happening. What today would the hypothetical landlord think of his chances to let, and how would he factor that into value? And my last point is a question that I think Lord Carnwath proposed to my learned friend. What should the Supreme Court do? And I think, if I may, I'd like to pick up on that. We say the question is, did the upper tribunal get it right on its own terms of its own decision? And having referred in particular to 102 and 106, we say yes, it absolutely did. Now, it is correct that there isn't an express finding of not obsolete, but we say that the findings that the upper tribunal did make, paragraph 98 and following, not struck with sterility, not intrinsically valuous, it's not a whore in national trust case, all of that in context mounts up to the upper tribunal not accepting that the property was obsolete. Now, we say that it's not right to look at the joint position paper as if it's an exam question. The Supreme Court shouldn't focus its decision on that. The Supreme Court's focus should be on the upper tribunal. And if the upper tribunal was right, then necessarily, for the reasons already given, the Court of Appeal was wrong. But it is possible, without wanting to speculate as to all the possibilities that might happen, it is possible that the Supreme Court might consider that the upper tribunal did not make sufficient findings of fact to support the conclusion that it did reach. So it is true that there is not a single finding from the upper tribunal that says this property was obsolete. There is not a single finding from the upper tribunal that says Mexford House hasn't in fact fallen off the cliff edge. It's not fallen off the cliff edge, it's still usable. Those findings don't expressly appear. We say that all of this can be inferred from what the upper tribunal did find, but it is possible that the Supreme Court might not agree with that. And if the Supreme Court's conclusion is that the upper tribunal did not make sufficient findings of fact on which to base their conclusion, then it seems to us that the right course would be to make findings of fact on those particular key points, and we would have thought the upper tribunal could do that quite easily because plainly it had those points in mind when it wrote its decision the first time round. We don't say that that is necessary, but I thought that I should at least address Your Lordship on that point as well.
Yes, it'd probably have to be a different tribunal, wouldn't it? I think Judge Huskisson's retired, isn't he?
Right, I wasn't aware of that.
I think so. Anyway, that's a detail.
Yes, we're certainly not suggesting that that is the cause, but bearing in mind the way that the arguments have developed, it might be that that is the conclusion eventually that this court reaches. My Lord, unless I can be of any further assistance, those are our submissions in your...
Thank you very much. We're grateful to all counsel for their assistance with this rather tricky problem, and we'll take time to consider our decision.